how many? No more than how many?
1623.
The blank shall adopt rules governing the number of terms which the grand jury shall be drawn and impaneled.
Appellate division.
Right. The term of impaneled grand jury exists at least and including the opening day of the next term upon such date or within blank days preceding it. The court may, upon declaration of the grand jury and the district attorney, and such grand jury hasn't completed business, extend the term to a specific date.
Pass.
With how many days?
Pass.
It's 5 days.
Okay.
I think it's 5 days. Yes. So if the grand jury hasn't finished doing their business, and the term is over, they have to give 5 days notice, or 5 days upon such date, within 5 days preceding the court, upon declaration of both the grand jury and district attorney. He has to declare that the grand jury hasn't finished their business. Okay. 5 days. The mode of selecting the grand jurors and impaneling the grand jurors is governed by
judiciary law.
Right. Neither grand juror or the panel may be challenged, but the court may at any time before or after the grand jury is sworn discharge the panel.
Okay, and you want the reason?
It's before. Before the grand jury is sworn, they can discharge the panel, but after the grand jury is drawn, they can refuse to swear him in or discharge him.
Upon a finding that if he's disqualified pursuant to judiciary law.
Right. Okay, good. After grand jury is impaneled, court must appoint one grand juror as blank and the other as blank.
Foreman, acting foreman.
Correct. Blank must appoint one of the grand jurors as the secretary before the commencement of duties.
Grand jury itself.
The grand jurors, right. After grand juror is sworn, the court must or may deliver to each grand jury a printed copy of the provisions of this article.
Must.
The court must or may give oral or written instructions.
That's a may.
Proceedings of the grand jury are not valid unless how many members are present?
12.
No.
Fuck.
16.
Shit. Oh,
remember,
that's right.
It's 16 to be present, but 12 have to be for
12 to vote or take an action. Fuck. Okay.
Right. 16 is valid. Finding of an indictment. Direction to file prosecutor's information. Decision to submit grand jury report. Every affirmative action or decision requires the concurrence of at least how many members?
12.
The blank can administer the oath to any witness before the grand jury.
The grand jury.
Any grand juror.
Any grand juror. Okay. And it's 16 for the members to be valid.
It's 16 to be valid and 12 have to be to vote for anything to be yes, I guess.
Okay.
All right, ready?
Yeah.
Only during blank and blank, only the grand jurors may be present in the jury room.
Deliberations.
And?
Voting.
Right. During other proceedings, blank may be present. Choose all that apply. I'll just say, you say yes or no.
Okay.
The witness?
Yes.
District attorney?
Yes.
Clerk and other public servant?
Yes.
Stenographic authorized?
Yes.
Stenographer authorized? Interpreter?
Yes.
Public servant holding witness in custody, and he must take the oath.
True.
Attorney for the witness?
Yep.
Operator videotaping a special witness or a child witness?
Yes.
A social worker, rape counselor, psychologist, professional providing emotion support for a child witness, blank or younger?
Child witness, 12.
Correct. And crimes involving sex offenders, providing who consents?
Providing the DA?
Yep. 14. The blank must provide the interpreter for the witness who does not speak English.
District attorney.
15. Upon request of the hearing impaired, the juror blank shall provide a sign language interpreter.
District attorney.
Right. When a district attorney has evidence a child has been abused, he must apply to the court advising the grand jury for an order permitting disclosure to who? Do you want me to tell you?
It's the central registrar or something, or?
You're very close. It's the State Central Register of Child Abuse and Maltreatment.
Got it.
Child witness is how old?
Child witness is 0 to 12.
Right, and the answer says 12 or less.
Yeah.
12 or less. Concerning what crimes and witness was a victim?
It's the Penal Law Article 130 crimes and Penal Law 255 crimes.
Sex crimes, right. And the witness was a victim. Special witness is...
Or a witness. It's or a witness, right?
What?
He's a victim or a witness.
Witness, where the crime... And witness was... It says concerning sex crimes and witness was a victim.
Oh, okay.
Special witness is A, unable to attend and testify in person because of physically ill or incapacitated. Is that true?
True. Or he's over the age of 12, but likely to suffer severe emotional trauma if he has to testify in person, and he was a victim or witness of one of the sex crimes.
More than 12, who is likely to suffer emotional and mental stress if required to testify in person concerning sex crimes, which he was a witness or victim.
Yeah.
In lieu of requiring a child witness to appear in person, child witness is what, 12 or under, right? Okay.
Yeah.
The district attorney may cause the examination of such witness to be what?
Videotaped.
Correct. If the district attorney has reason to believe the witness is a special witness, he may make an ex parte application to the court for authorizing videotape examination, and application must or may be in writing.
Must.
The application must or may state the grounds.
Must.
The application must or may contain sworn allegations of fact of the DA or other person supporting grounds.
It's a must.
Right. Videotaping of a child witness or a special witness may be conducted may be conducted when?
When?
Monday through Friday, 9 a.m. to 3 p.m. at a special location.
I had no idea.
You should do, because you said the answer to me before.
I did.
Anytime, anywhere.
That's the answer? Anytime, anywhere?
Yep.
Okay.
Videotaping of a child witness or a special witness may be conducted anytime, anywhere.
Okay.
22. Operator begins a videotape by recording a statement by who of the date, time, and place.
The DA.
And shall identify himself and all of the persons present. The blank shall be placed next to or behind the witness.
A sweeping secondhand clock or a time date generator.
Right. Who may be present during the videotaping of a child witness or a special witness? You want me to just name them?
Just name them, yeah.
Let me just see if it's all of the above. Okay. These are the people who can be present during the videotaping of a child witness or a special witness. The district attorney, the clerk or the other public servant, the stenographer authorized, the interpreter, a public servant holding the witness in custody, an attorney for the witness, the operator videotaping the special witness or child witness, a social worker, rape counselor, psychologist, professional providing emotional support, and a doctor, nurse, other medical assistant. 25. District attorney shall state on the record the name of the witness, the caption, the grand jury number if there is any, and if the witness is a special witness, the date, the order authorizing the videotaping of the examination, and the name of the justice who signed the order. Okay. You got that? 26. District attorneys are required to submit evidence to grand juries. The district attorney must or may submit evidence concerning a felony.
Must
or may submit evidence concerning a misdemeanor.
May.
No, I think that's it's a... Wait, I could be wrong. It's a must.
Oh, okay.
Must or may submit evidence concerning an offense.
Must?
That's a may.
Oh.
So the musts are the felonies and the misdemeanors. The DA is required to submit evidence to grand juries.
Okay.
After a hearing and examination, a grand jury they can do one of 6 things.
All right, so let me see.
They can do one of 5 things.
Let me see if I can name them. Indict a person. Direct the DA to file a prosecutor's information. Direct a removal to family court. File a report. And refuse to indict. Dismiss, okay.
You got them all.
All right, cool.
You want me to
you want to? Yeah, you could read them in your voice.
All right. After hearing an examination, a grand jury may do 5 things. They may indict. They may direct the DA to file a prosecutor's information. They may direct the DA to file the request for removal to family court. They can submit a grand jury report, or they can dismiss the petition. Petition or accusatory instrument? Sorry.
Yeah, the whatever it is.
I said petition, but I think it's accusatory instrument. Okay. A grand jury may indict a person for an offense when the evidence is legally sufficient that the person committed the offense. Evidence is not legally sufficient when corroboration required to sustain conviction is absent and competent and admissible evidence provided blank he committed the offense. What is the standard of proof? The standard.
Reasonable cause.
Yup. How do I remember that?
Because it's the same as in the felony hearing.
Reasonable cause believe. Okay. A grand jury may direct the district attorney to file what?
A prosecutor's information prosecutor's
Charging the offenses other than a felony when the evidence is legally sufficient that the person committed offenses and competent admissible evidence provided what he committed the offenses.
Reasonable cause.
Reasonable cause again. Right. And the grand jury must, through blank or blank, must file the direction.
Through their foreman or acting foreman.
Right. And be signed by who and who?
The foreman or acting foreman and the DA.
Right. No, it just says foreman.
Oh, shit, okay.
The DA. A grand jury may not indict a person 13, 14, or 15 unless he is considered a juvenile offender. True or false?
True.
Right. 190-71. Grand jury may vote to file a request to remove to family court if it finds a person 16 or younger did an act which is done by a person over 16 would constitute a crime, provided A, such act is one it may not indict. 2, it does not indict such person for the crime. 3, evidence is legally sufficient to establish such person did the act. And 4, competent and admissible evidence provides reasonable cause to believe he did the act. And it's all of them.
Okay.
But the key there is the 16 and 16. The grand jury may vote to file a request to remove to family court if it finds a person 16 or younger. So it's 16 or younger did an act which, if done by a person over 16, would constitute a crime. Okay, because that's a JD, 16, right?
Yeah.
All right, so that makes sense. Up to 16, okay. Upon voting to remove to family court, the grand jury must through blank or blank file a request to transfer to family court.
Through its foreman or acting foreman?
Foreman or acting foreman, right. And the request must allege that the person did the act, if done by a person over 16, would constitute a crime, and specify the act's time and place of the commission, and be signed by the acting foreman and foreman. We only have 3 more questions on this stuff.
Oh, good.
We're flying.
Oh, I hope so.
At what time is it? Oh my God, it's already 3:30.
I know.
Oh my God, I can't. We didn't even do shit today.
I know. We didn't even get through the criminal, but we'll do it. We'll have to finish tomorrow.
We have like, you know that saying when you want to eat and your eyes are bigger than your stomach?
Yeah.
We say we're going to do so much, and then when we do it, we don't have the time.
I know, but we did the rest of the family.
And you know what? It's good that we did refresh this, because I feel a little more confident now about criminal.
Me too.
All right. If evidence, we didn't even get to the good stuff yet. We didn't even do 722 yet.
I know.
All right. If evidence is not legally sufficient or a grand jury is not satisfied, there is reasonable cause to believe he committed such crime, it must dismiss the charge. When charge is dismissed, it may not be submitted to the grand jury again unless the court in its own discretion authorizes or directs the people to resubmit to the same grand jury or another grand jury. If charges are dismissed again, it may or may not be submitted again.
No, that's it. You get one second chance. That's it.
Right. Whenever all charges have been dismissed, the district attorney must, within how many days of filing the finding of the dismissal, notify the person of the dismissal by regular mail to his last known address. Oh, remember we said this? So it's dismissed and he's going to sit home for 3 months or something.
Oh,
it was like
it was something ridiculous, right? It was like 90 days.
It's 90 days.
Oh my God. You know, I didn't remember that until you started talking about it, but...
Yeah, because we're like, all right, so the guy, now he's free. Now they don't give a shit. Yeah, all right, stay home. The guy's scared to go out of his house.
And then in 90 days, they got to do...
Right. Or if the case of a juvenile offender or adolescent offender, how many days?
I don't know. I didn't even remember it was different.
Oh my God, I said the wrong time frames. I'm reading the wrong question.
Oh.
That was the wrong question I just read. Sorry. That was right. It was 90 days. And then the next question is what I just misspoke about. Upon the application of the defendant, basis felony complaint being held for the action of a grand jury, who has been committed to the custody of the sheriff, pending grand jury action, who has been confined for more than how many days?
45.
45 days, but in the case of a juvenile?
30 days.
Right.
And what does it say? What's the rest of it?
It says, or in the case of the juvenile offender or adolescent offender, 30 days, without the occurrence of any grand jury action or disposition, the supervisor court who impaneled the grand jury must ROR him unless lack of dispo during the confinement was due to the defendant's request or action, or occurred with the defendant's consent, or people show good cause why the order of release should not be issued. And we just did 190.
Yay! Okay, so I'm going to upload that.
Let's do 195. It's really short.
All right, good. Let's do 195.
Okay, 195 is about the waiver of the
indictment
to be prosecuted by the Superior Court information, right?
Yeah.
So it says 195, a defendant may waive indictment and consent to be prosecuted by what?
Superior Court information, SCI.
Correct. And when a local criminal court has held the defendant for the action of the grand jury, and the felony complaint was filed, the defendant is not charged with a blank, they must indict a Class A felony. What?
I don't know.
Let me read this again. When a local criminal court has held the defendant for the action of the grand jury, and defendant is not charged with a Class A felony, they must indict. District attorney must or may consent to the waiver.
The district attorney must consent. I think what it's saying there, maybe...
I think what I'm saying is if it's a Class A felony, they must indict.
Yeah, they can't do an SCI. They have to indict him.
So let me read that again. If the defendant may waive the indictment and consent to be prosecuted by a Superior Court information, and when the local criminal court has held the defendant for the action of the grand jury, and the defendant is not charged with a Class A felony, the district attorney must consent to the waiver of indictment.
Yeah.
Okay. And if it is a Class A felony, he can't waive the indictment. He has to be indicted.
Yes.
Okay. Next question. A defendant may waive indictment either A, in the local criminal court that issued holding the defendant for the action of the grand jury at the time such order is issued, or in the appropriate Superior Court at any time prior to filing the indictment. Right? Prior or after A and C should be. Yep.
Yeah. It's so if it's in the local criminal court, he has to do it at the time he's held.
At the time. And if it's in the and isn't there like a 10-day rule in that? He has 10 days to do it?
No, the 10 days is that they have to send it. The DA has 10 days to file the SCI.
Right.
And then
so
but if he does it,
waiving the indictment.
But if he waives it in local criminal court, the DA has 10 days to file the SCI. If he waives it in Superior Court, it has to be filed at the time
of filing.
Yeah.
At the time of filing. Okay. Yeah, because he's already there.
Yep.
Okay. Waiver of indictment shall contain what? It has to contain 4 things. The name of the court where it's executed, the title of the action, the name, date, and approximate time and place of each offense to be charged in the Superior Court information. That's it.
Okay.
No 3 things, just 3 things. Waiver of indictment to be filed by who?
The waiver has to be filed?
Filed by the district attorney.
Okay.
Okay. 5, waiver indictment shall contain a statement by the defendant that he is aware that A,
under the state of New York Constitution, he has the right to be prosecuted by indictment filed by a grand jury. That he waives that right and consents to be prosecuted by Superior Court information filed by the DA. That the Superior Court information will charge the offenses named in the waiver, and that it'll have the same force and effect as an indictment charged by a grand jury.
Very good, smarty pants. Waiver of indictment shall be evidenced by what?
A written instrument.
The written waiver shall be signed by the defendant in open court in the presence of who?
His attorney.
And the consent of who shall be endorsed on it?
The district attorney.
And when indictment is waived in the Superior Court, the district attorney shall file what in such court?
The SCI.
Right, and he has to file that when?
At the time of the waiver.
And when the indictment is waived in the local criminal court, the district attorney shall file what?
The SCI within 10 days.
10 days of the execution of the order approving the waiver. When indictment is waived in the local criminal court, this is just reiterating it again, I guess. When the indictment is waived in the local criminal court, the district attorney shall file the Superior Court information within 10 days of the execution of the order approving the waiver. And if the district attorney does not file the SCI within 10 days, and the defendant is in custody more than how many days, the Superior Court must ROR?
10 days.
Yep. That was it.
All right. So,
we're up to 200.
Do you want to do just 200?
All right. It's not that long.
Yeah, I remember it was pretty short.
We're rushing through them, so I'm okay. We're good.
Yeah, we're good for now.
There's a million things I want to do. I want to work out, but, we did a lot, but I got nothing new done. Maybe when I'm done with you, I'll do my workout, and then I'll do my videos on family and get that over with.
Yeah.
And then I'll go back to making my criminal video or something.
Right.
Yeah, we keep saying we're going to do all this shit, and we just don't have enough hours in the day.
There's just not enough time.
Am I right?
I know. All right, let's keep going. Let's do 200, then we stop for now.
It would be great if we can get through all the criminal.
I know. Well, let's see how fast we can go.
200. An indictment is a written instrument by who?
A grand jury.
Filed with who?
The Superior Court.
Charging a person with a commission at least what?
Crime.
A Superior Court is an information written by who?
DA.
Filed with who?
Superior Court.
Charging at least one what?
Crime.
A Superior Court information may include offenses which defendant was held for the action of the grand jury or offenses properly joinable, but shall not include offenses not named where?
In the waiver.
Right. Waiver in the waiver of indictment. 5, indictments must include at least one what?
Crime.
Right. And the next one I'm just going to read because it's a list of things that the indictment has to contain.
Yeah.
And I'm just going to read them, and there's a few things that you could scream out in them.
All right. I know one's the name of the court. The name of the Superior Court.
1, A, name of Superior Court in which it was filed. 2, B, the title of the action. C, where the defendant is a juvenile offender, a statement that the title that the defendant is a JO. D, a separate accusation or count addressed to each offense charged. E, a statement in each count that the grand jury or where the accusatory instrument in the Superior Court information or where the accusatory instrument is Superior Court information, the DA accuses the defendant of a designated offense. Any prosecution under Article 485.05 Penal Law hate crimes shall be filed by the phrase
as a hate crime.
And any prosecution under terrorism shall be followed by the phrase
as a crime of terrorism.
F, a statement in each count that the offenses charged were committed in a designated
county.
G, a statement in each count that the offenses charged was committed on or about a designated date or during a designated period. H, a plain and concise factual statement of each count with or without allegations.
Without.
I, assert facts supporting every element of offenses charged. J, armed felony, state that such offenses is an armed felony and implement possessed. K, hate crime, that defendant intentionally selected person because of race, religion, etc. L, crime of terror, that the defendant acted with intent to intimidate
a population.
What?
Intimidate or coerce a population?
Yes. influence the policy of the United States of the unit of government by intimidation or coercion, or conduct of a unit of government by murder, assassination, or kidnapping. And also M, the signature of who?
The DA.
And the signature of who?
The foreman or acting foreman.
Yes. 7, at any time before or during the trial, the court may, upon application of who, and notice to who, an opportunity to be heard, order the amendment of the indictment with respects to defects, errors, or variances relating to forms, time, and place names, and such amendment does not change the what?
Theory of the prosecution, and it's the DA that makes the application on notice to defendant.
Exactly. So one more time. At any time before or during the trial, the court may, upon application of the DA and notice to, did I read that right?
Wow, during the trial. Oh.
Yeah. It's an application to the people and notice to the defendant, an opportunity to be heard. They can amend the indictment for errors, defects, and variances relating to forms, times, and place when such amendment does not change the theories. An indictment may not be amended for what?
Misjoinder of offenses, misjoinder of defendants, a failure to state a crime, or a failure to charge an offense, or
state an offense. You're right.
Or state an offense, and that changes the theory of the prosecution.
Yep. It's failure to charge or state an offense, legal insufficiency of factual allegations, misjoinder of offenses, misjoinder of defenses, and if it changed the theory. And FYI, the 3 in the family court were failure to charge or state a crime, legal insufficiency, and misjoinder of offenses. Misjoinder of defenses and the theory was not in the family, remember? It was
wasn't.
It was only 3 things, remember?
Yep.
And it wasn't the defendants and it wasn't the theory. If I remember correctly.
You're right.
Okay. 9, a bill of particulars is a written statement by who? Who writes the bill of particulars?
The police or public servant?
It's the prosecutor.
Oh.
A prosecutor.
Okay.
A request for the bill of particulars is served by who?
The defendant.
Upon who?
The DA. On
Right.
the court. No, it's on the court.
It says
it's on the court.
Number 10 is the defendant people. It says request of the people of the bill of particulars is served by the defendant upon the people.
Oh, okay.
Yeah, because they're the ones who have to serve.
That's what you know what? You got to go with your first instinct, because my first instinct
because remember,
was that.
they're the ones who are going to supply it. Remember, this is without leave of court.
Yeah.
Remember? The bill
and you know what? In local criminal court, I think it's the other way, but...
Great. I haven't gotten there yet.
Yeah.
All right. Next question. The bill of particulars is timely if made when?
Within 30 days.
After what?
Arraignment.
And before what?
Commencement of a trial. Or
right.
Yeah.
If the defendant does not have counsel and wants to adjourn to get counsel, that 30-day period begins when?
When counsel appears.
And the prosecutor shall serve a bill of particulars on the defendant and file it with the court when?
Within 15 days.
Of what?
Of the request.
Right. Or as soon as they're practicable.
Oh, right. As soon as...
The prosecutor may refuse to comply with the bill of particulars if he believes that 1, the item is not necessary for the defendant to adequately prepare his defense, or 2, a protective order would be warranted, or 3, it's deemed untimely, or 4, he doesn't feel like giving it to him.
It's the first 3.
Right. And such refusal shall be in writing and set the grounds. Last question.
All right.
The refusal shall be served upon the defendant with a copy and filed with the court when?
Within 15 days.
Right. We're done with that one. Wow, I'm feeling much more confident already. All right, the next one is 215, and there's only 10 questions. We're going to read them fast again.
Okay.
215. Upon arraignment in a local criminal court, upon what? Upon a felony complaint. Or upon arraignment in a superior court, upon what? an indictment or a superior court information. So we're talking about felonies, obviously.
Yeah.
And before the final disposition, the court may order ACOD with consent of who?
The defendant.
Consent of the people, consent of the defendant, consent of the court, and reasonable notice and opportunity of the victim to be heard.
Oh, shit. Okay, I don't remember this article.
So this is an ACOD. You know what? I want to do just an ACOD test. You know what I mean?
Yeah, you know what? I want to put this one in a different video, too.